the next.
Good afternoon. My name is James Vann, and I'm an attorney here with Vann Attorneys. We're so thankful that you could join us today for our webinar. We're going to be talking about attorney's fees and finance charges in business contracts. And look forward to, hopefully, if you have questions, you may submit them one of two different ways. You may either email them to webinar@vannattorneys.com, or you can use the control panel on the GoToWebinar control panel portion, submit your question, and then I think hit send or submit there, and we'll be glad to answer those questions. Also, just for your help, if you want to mark your calendar, our next webinar will be October 25th at 3 o'clock. Again, October 25th at 3 o'clock. And if you've got a topic that you think that would be helpful to you, please send that to me, and you can send it to my email if you want to, and it's jrvann@vannattorneys.com, or you can use the webinar@vannattorneys.com. Either way, we'll get it. And if we choose it, actually, I'll tell you what, if you submit a suggestion on business issues, we'll take you to lunch. How about that? Give you a free lunch and get a chance to just hang out together. But if you want to do that, we'd love to hear from you. So let's talk about how to recover attorney's fees and finance charges in business transactions. We represent a lot of different business entities and across the state, and almost always when we get involved, people ask us, "Hey, can I get my attorney's fees?" And it's amazing. That's a great question to ask. It's always something in someone's mind. So hopefully, what we talk about today will be beneficial to you, and that will give you some information about how do you recover attorney's fees. We're going to talk about several statutes in North Carolina that allow that. So we're going to look at North Carolina law. We're going to talk about when you can recover, how do you recover, and is there a limit to what you can recover for both attorney's fees and finance charges. So let's go ahead and dive in. Under North Carolina law, there's a general rule in North Carolina that's fairly old, and unless the statute provides for attorney's fees, the parties generally are responsible for their own fees. That's a long-standing common law provision that most courts have followed over the years. So again, unless there's a law or a statute that specifically provides for it, again, everybody handles their own costs. Even when a party has agreed in a contract to reimburse another for attorney's fees or a party's fees, that's the case. Now, again, if there's specific language that talks about reasonable attorney's fees and a statute provides it, then that's great. But if a statute does not provide for it, generally the courts will not allow it. Now, there is a new statute that came out that was enacted in 2011, which if your contract calls for it, then you, in a business context, then you typically have the ability to recover attorney's fees, and we'll talk about it in just a little bit. So one statute that a lot of you that you know about because it's in your contracts, because a lot of them we know we've put in there for you, is 6-21.2. This is what's called actions on notes and other evidence of indebtedness. That's sort of a long answer or phrase for the terminology of what they're trying to cover. But in general, the statute says upon any note, conditional sales contract, or other evidence of indebtedness. It's broadly defined, and it's intended to be that way so that the statute can cover a whole gambit of types of contracts. And it does include open accounts, and it also includes credit accounts. I know a lot of you have open accounts where you have a business-to-business transactions, and in that transaction, you may have a line of credit. You've given them or extended them a line of credit, in essence, or an open account up to a certain dollar amount for this person, this company to expend with you. So in 6-21.2, if you have a provision in your contract for reasonable attorney's fees, that's included in that. Or if you just have a business context, just a typical business contract, it's a one-time type transaction. If you reference reasonable attorney's fees under 6-21.2, and you actually don't even have to mention the statute, you just say reasonable attorney's fees, then it falls in under 6-21.2. The courts have defined this statute, that is the 6-21.2, as the provision that says, you know what, we'll allow you up to 15% or 15% of the outstanding balance due on the contract. So, for example, if you've got $100,000 that's owed to your business and you have this provision in your contract, you can recover up to 15% of that $100,000 in attorney's fees. Well, suppose you don't spend that much with the attorney. Well, that's great. Then that means, in essence, you have a windfall for the provision. So if it's a $100,000 case and 15% of that would be $15,000, let's say the attorney's fee is actually $10,000, so there'd be a $5,000 surplus if you recover all that comes back to the company. So that's a nice offset. If it's obviously the dollar amount that's owed to your business for whatever reason is a smaller dollar amount than the 100, and it's you should apply the 15, and the attorney's fees are actually in excess of that dollar amount, then unfortunately that's the time period when it starts costing the business money. So the good news is again, depending upon what the dollar amount is, you hopefully can come out, if not 100%, really close to it. Generally, this is not in the discretion of the court. So the 6-21.2 is generally, the court does not have discretion as to whether or not to award that. If it calls for reasonable attorney's fees and it's in the context that we've talked about thus far, mostly the court has to or is obligated to grant the attorney's fees. If the contract sets a percentage, the court must enforce it as long as it does not exceed the 15% of the outstanding balance. So let's say, for example, I've seen some contracts that say, and they're drafted from a different state, the reasonable attorney's fees up to, or 25% of the balance due and owing. Well, the court is not going to grant that. In North Carolina, they're going to limit to 15%. So you just need to think through that a little bit. If you're in multiple states, we've helped people when they have sales in multiple states, like a whole bunch of them, not all 50, but we have come close to that. You got to think through that, how to word it so you can get attorney's fees in as many jurisdictions as you can if you're using just one contract. So the court is not required to find that the 15% fee is reasonable. Thankfully, they don't have to do that, and that's a safety net for actually recovering that. When the contract provides for a percentage range, the court must take a much greater look. So, for example, let's say your contract provision says reasonable attorney's fees of not less than 10%. Well, what does not less than 10% mean? The court's then got to take evidence to determine what that means, and it just takes longer. It gives the court more leeway, if you will, and more discretion at that point to start looking into whether or not that's actually reasonable or not. Or another example is not exceeding a sum equal to 15%. Again, that's similar language to what we just talked about, and the court is going to take at that point has to hear evidence to determine whether or not it is reasonable. So if you just say reasonable attorney's fees or reasonable attorney's fees according to 6-21.2 of the North Carolina General Statute, if that kind of language is in your contract in North Carolina, then you're going to be good on the 15% portion. So hopefully that's helpful to you. We've got a poll question we'd love to have you give us your answer to, and it has to do with attorney's fees. So the poll question is popping up now, and hopefully you can see that. If you will, take a vote and let us know whether or not your office or your business has an attorney's fees provision in your contract. So I can't see the number, but we're getting close, I think. So if you will, we're going to close out the vote here in just a few seconds. If you haven't voted, go ahead and do that. And then we'll take a look at the poll result. We'll show that for you. So I can't see it. I'm trying to, it's 100%. All right. I am so thankful for Michael Fernald in our office who handles this for us. So the good news is 100% of y'all have that in your contract. That's awesome. So hopefully I'm preaching to the choir here, so that's a great thing. All right, let's look to other evidences of indebtedness. If the contract is not specific but calls for reasonable attorney's fees, the court should allow a fee of 15%. So again, in your contract, you've got a reasonable attorney's fees provision, and the contract calls for it, then that's protected. You should be able to get the attorney's fees out of that. So let me back up here just one more. What about outstanding balance? How is that defined? The principal and interest owing at the time the suit is filed. So if you look at, for example, the outstanding balance, how do you define what that is? The statute says you get up to 15% of the outstanding balance. The statutes and case law says that it's the principal and interest owing at the time suit is filed. It is possible to include previous amounts demanded prior to the filing suit if, say, they paid for something. Let's say, for example, that you send a claim to us, we help you with it. We send a demand letter, say it's $100,000, and in the demand letter, it says they have to pay within 5 days. Let's just say that the customer paid within, say, 15 days, but they paid the original balance or demand was 100, they paid 50, so they leave another $50,000 owing. They're refusing to pay that part. So we file suit on that $50,000 that of the outstanding balance, but we're going to claim attorney's fees on the $100,000 balance because that was what was initially owed, and they did not pay when they were supposed to. So you can recover that, and that happens. That happens to us sometimes. So again, the principal and interest owing at the time. So you can include principal interest up to the time you're filing, and then of course we would, in the complaint, ask for the finance charges thereafter. But if there is finance charges already built into it, you can recover the 15% attorney's fees on that as well. What about what's called other evidence of indebtedness? What does that mean? Under North Carolina courts, they have held that the following types of agreements, these are business contracts, fall within that definition. So if it's a commercial real estate, say, property lease, or if it's a personal property lease, say someone's leasing equipment maybe, or credit agreements and credit applications with credit accounts, those fall into other evidences or of evidence of indebtedness. So, because it's not a note, it's not a promissory note, those are evidences of indebtedness. And there's a several handful of other types of contracts, but the good news is on the business side, this is covered in that portion. Also, the credit applications with credit accounts. What about when you have a personal guarantee that's guaranteeing the corporate account with your business? Is the personal guarantee liable for attorney's fees? If that type of language is included in the personal guarantee portion, then yes. I know a lot of times we help draft credit agreements or contracts for companies, our clients, and in that they ask, we're always trying to keep it as brief as we can, but at the same time enough to cover you what you need for your business purposes. And I have had clients before say, hey, look, we don't need to refer to the finance charges and the attorney's fees again. We've already mentioned that in the portion above where the original customer signs. And unfortunately, that makes sense, but it's not how the courts interpret it. Courts say you got to have the finance charges provision and the attorney's fees portion significantly and specifically referenced in the personal guarantee portion. So thankfully that doesn't come up a whole lot, but at the same time, if you're redoing your credit application and looking at it, it's probably a good idea to have that included in the personal guarantee section or language as well. So what about actions on the notes, and what do you have to do in order to trigger the attorney's fees? Generally, you got to give a notice provision. You got to have some kind of notice to the customer to trigger that. And interesting enough, the statute calls for an attorney actually sending the notice. It doesn't. Obviously, you can send a demand for whatever your customer owes you, and hopefully that works. And if it doesn't, can you write a letter to your customer? I guess the question would be, and demand payment, and if they don't pay within 5 days, then they're liable for attorney's fees. You can do that. Does that trigger the statute? There are some cases that say it does not. But let's say you send a letter yourself, you don't get a response, we then file suit for you. In that case, I think the court's going to grant the attorney's fees. They're probably not going to go and look behind it because we're enforcing the demand. But at the same time, it opens the door. So I hate that's the way the court has interpreted, but that's in reality. Still, how do you send that notice provision? Mail is the most preferred method. We certainly suggest certified mail return receipt requested because it then shows the proof that they actually got it. So hopefully that helps as well. What about non-justiciable cases? This is another provision where you can try and recover attorney's fees in a case. We just actually had this happen recently, where our client got sued and it made no sense. The case made no sense whatsoever. None. I mean, it's just one of those. You think, how crazy can this be to get sued for this? And in reality, what they were, the person that was suing our client, it was a business to business. They were arguing about something that our client had allegedly done, and our client got that corrected. But in the interim, they filed suit against our client, and they said, we want you to pay our attorney's fees. And our client was like, no way, not doing that. So there is a provision under 6-21.5, if it's a non-justiciable case, you can ask the court for attorney's fees. And how that looks at is, it's got to be a civil case and on a motion of the prevailing party. The prevailing party is defined as a party who receives 50% or more of what they've asked for. The court must find that there was a complete absence of justiciable issues of either law or fact. And then it's up to the discretion of the court. And so the reason that is important is the judge gets to decide what's the right thing to do in their eyes, which sometimes is helpful and sometimes it's not. That's just the way that's how it shakes out. It's not limited to a percentage amount of outstanding due and owing. So there's not the 15% factor in this case, and as we talked about in 6-21.2. In a non-justiciable case under 6-21.5, the court looks at whether or not which party won, what did they recover, and whether or not there was either a real question of law or fact there. So in this case, I was saying about, we just wound this up, I think last week. We filed an answer. This thing went on for like 2 years. Had depositions, discovery. It was ridiculous. We spent a lot of money. The good news is the court eventually agreed with us. The unfortunate part is that they did not agree with us on the attorney's fees. And the court said, in our discretion, we think that the attorney's fees should not be awarded. And they had a reason for it. And the reason I share that is this: I have had judges occasionally over the years that would grant attorney's fees in a case where where the court has discretion. But it's one of these things. If you think about it, if one of the parties has a somewhat valid reason for whatever they're doing, then the court says, you know what, okay, we're not going to grant attorney's fees. Or if it's just absolutely egregious and it makes no sense whatsoever, then sometimes they will. But if there's even a part of a question to that, the judge may or may not grant the attorney's fees. And the reason I say that or explain that to you is this: it's just important to know what the standard is, what the test is, when you're trying to figure out what to do. This was one of those cases of principle for our client. This client just did not want to pay the other side's attorney's fees, and they were right in doing that. But principally based cases, I always tell our client, hey, sometimes you got to draw the line in the sand, but sometimes principally based cases taste really bad when it's over, even though you're right. Number one, and number two, they're generally pretty expensive. So you just got to be prepared for that if that's what you want to do. But at the same time, being held hostage isn't much fun either. So hopefully that helps and that makes sense for you. What about recovering attorney's fees under another statute called the reciprocal provisions for attorney's fees? This is a new statute that I talked to you about just a minute ago when saying this had come on board on 2011. And there has been one case that has gone to the Court of Appeals of North Carolina having to do with this case. And interesting enough, the Court of Appeals took it up, heard it, but they kicked it back to the trial court, not because of the attorney's fees provision, but another. So we still don't have any answer from the Court of Appeals as to how they interpret the statute. But the way it's written is this: it authorizes the court to enforce what's called reciprocal contractual attorney's fees provisions in business contracts. So again, it's got to be reciprocal. It can't be one way or the other. It's got to be both ways. This is very similar to a majority of other states, the language that's in the statute. So under this provision, it's in the business contract. It's contracts that are entered into primarily for business or commercial purposes. It does not include consumer contracts, for example, personal, family, household, that kind of stuff, or employment contracts. So it's only in the business contract context for business contracts. And again, the reciprocal portion, the statute says it's made for all parties, that either party may have to pay or reimburse the other for attorney's fees by reason if a suit was filed or action or even arbitration was filed. So this provision covers both cases in a civil case in the court, or if you're doing arbitration, which again, some people used to have arbitration provisions in their contracts all the time. We really encourage you not to do that because it's not as inexpensive as it used to be, and it's not as time-consuming or time-saving as it used to be. It's actually almost as expensive now as the courts, and it takes a long time to get through it as well. Arbitration is still a good idea under some circumstances, but just not in all of them. So again, hopefully this helps you to understand a little bit about the reciprocal portion. Interesting enough, this statute as part of it, has a provision that says it's got to be signed by hand. Literally, this is 2011. Electronic, commerce is pretty active by 2011, and it says it's got to be signed by hand. It doesn't define what that means. So it didn't say how that should happen or what that meant. It just said signed by hand, and that is not a legal term that has a otherwise legal definition. So it's not like we can go look at something else. It might include electronic signatures or other types of ways of delivering and accepting contract terms. I've read a bunch of articles about this provision, about this portion of the statute. Some people think that the language was added, and in fact it was added in the latter part of the negotiation for this statute before it was actually passed. So some people said they think that it really means that you got to have to sign it by hand. It's got to be I refer to blue ink and white paper. versus signing it electronically or signing it and then scanning it and emailing it. Everybody's got to sign it by hand. That's what it says. I'm not sure if that's what it means, but that's what it says, and we haven't had a court to distinguish that yet. I will tell you, and many of you know because you've been on our webinars before, there's two pieces of legislation, one's federal and one state, having to do with electronic contracts that actually I think overrule this provision that says that's got to be by hand, because those other provisions say that a contract entered into for business purposes can be by electronic means. That could be by your phone, it could be by your computer, it could be, however you do it electronically, it could be an electronic signature, and I think that would be binding. Only question, I guess, is if someone would say, well, this statute specifically says by hand, and so therefore it's got to be. I don't have an answer for you, but that's what it says. Under 6-21.6, again, under the reciprocal provision, it's got to be reasonable. The court's got to look to how much, what was the amount in controversy and what was the result, who won, the reasonableness of the time and labor that was expended by the attorney and the paralegals. What's their rate? Is that reasonable? Is there a difficult question, legal question that was heard? What skill was required? That kind of stuff. So that's sort of what they look to determine that. In general, in North Carolina, you can recover attorney's fees, as we've talked about in business context, but you got to have, number one, a statute that allows it, and you got to have it in your contract. So hopefully you do. If you have any questions about that, please feel free to contact me. I'll be glad to look at yours, talk to you about it, and help you if you need help with it. But I'll tell you, if you don't have that in your contract, you're leaving it on the table. And it is a great way, if you wind up getting into litigation, I'm not encouraging that, but I'm saying if you do, it is a great way to build in a little bit of extra cushion to allow you to negotiate. Quite often times, when we help clients, they wind up having attorney's fees and finance charges in there. And let's say we get a judgment, and then we start trying to find the assets, and we execute on that judgment. The attorney's fees, and say, for example, if the finance charges have, it's a fairly high number and it's been on there for a number of years, that gives you great leverage in your negotiating and still get majority of your principal, if not all of it. And the attorney's fees and finance charges gives you a little bit of provisions to have some negotiating room. So let's look to finance charges for a few minutes in North Carolina. In general, North Carolina courts will enforce the finance charges or the interest provisions in the business context and for contracts. It also depends on the type of facts and who the parties are. North Carolina only will enforce finance charges for business-related transactions up to a statutory limit, depending upon the type of transaction, and that means if it's real estate or if it's a credit card, that kind of stuff. So sometimes there is a limit built into it. In North Carolina, finance charges are categorized by the type of transaction, and the statutes specifically tie to that, as we've said, credit cards, business, personal, household, real estate, and so forth. But outside of that, if it's just a business-related transaction, let's say, for example, that a business is going to finance something for another business, a business transaction. Quite frankly, they can charge almost any kind of provision for finance charges. And I've seen some that are, in the 20s because of the risk that's involved. The courts will uphold that. What about business loans and or business transactions on open accounts and revolving credit charges? So, for example, a company opens up a credit account for their customers. In that respect, the general statute is 24-11A. And you're limited to 18% APR, 18% total, 1.5% per month. Let's look at just for a moment. We help a lot of clients that are all up and down the southeast and around the country. And let's say, for example, that another state allows 2% or 24% APR in finance charges, but they sue their customer here because that's where their customer is based out of. How much can they Can they get the 2% because that's what's allowed in their state, or are they limited to the 18%? In North Carolina, they're going to be limited to 18%. Now, let's say, for example, that they've already sued their customer in another state that does allow, say, the 24%. They have a judgment, and they want to enforce that judgment here. Then we can enforce it here at that point. But if you're initiating a lawsuit here, you cannot. So the general respect in that is 1.5% per month, or 18%. Just for your knowledge, the legal rate in North Carolina is 8%. That's still not a bad provision, but just so you'll understand that. One of the provisions that we really have suggested our clients include in their contracts is interest on judgments. Let's say, for example, that you have to sue your customer because they haven't paid you, or they breached the contract and there's a dispute on how much is owed. Let's say you win, and you've got a contract provision of, say, 1.5% per month on what they owe you. If you reference in your business contract interest at 24.5, the general statutes, that actually gives you your contract rate of interest until they actually pay it. So let me back up just to make sure I understand or explain that the right way. Your provision, your contract says 1.5% per month is the finance charges that you have assessed. But let's say, for example, that it doesn't reference anything else after that. Well, the statute says you'll get 1.5% up to the point of judgment, and thereafter it's going to be at 8%. Which again, 8% is not bad. It's better than zero. But let's say, for example, you reference in your contract this 24-5, then you get the 1.5% from day one of what they owe you until they pay the judgment. So that next, say, while you're looking for assets, let's say it's a year before you recover on the judgment, you get the 1.5% for the next year. So again, it gives you great leverage in negotiating authority or power with your customer if you have to do that. So hopefully I'm just saying, if you're going to do it, might as well put that in there because it gets you a little extra. Otherwise, the legal rate applies after that. I hope this is helpful to you. I hope this helps you in your business contacts and your contracts. If y'all have any questions, please let us know. We'll be glad to help you, and really would love for you to let us know if there's something we can help you with specifically. If you're not following us on social media, we'd love for you to do that, and we try to push out information that's helpful to our clients. Just connect with us. And again, thank you for letting us be a part of your business. If you have questions, please feel free to reach out to me. And again, if you have not and want to send us a topic for our next webinar, you can use the webinar at vannattorneys.com or email me directly at jrvann@vannattorneys.com. Thank you so much, and I hope you have a great day.